broadcast tonight. We have some questions. We have some breaking news. Hopefully we're going to have some answers from part of Ammon Bundy's legal defense team. This is regarding the Nevada Bunkerville trial. Tier 1 is kind of what we're going to start off talking about. And so with us tonight, we've got Ammon Bundy's attorney, Morgan Philpot. And then we've got some supporters and some helpers also, and that's Rick Koerber and John Lamb. And I am Kelli Stewart. I know there was some questions the other night on the broadcast that we did about who is Rick Koerber and what is his role in this. And so just to let you guys know, he's here just being a voice. He's a brilliant man, and we're very blessed to have him amongst us. He helped in the not guilty verdict that Ammon Bundy saw October 27th when he joined that team. And while he will not actually be on the team in Nevada, he will still be working tirelessly behind the scenes to help guarantee another, God willing, another not guilty verdict in the Nevada charges in the Nevada trial. So we're happy to have him with us. We're happy to have Ammon's attorney with us and John Lamb. And while people start to come on, I guess I don't have my computer up, so I do not know where we're at as far as an audience yet. Can you guys let me know, Rick?
It looks like we got about 11 people so far.
Oh, well, we'll talk for just a quick second and let people come on.
And you got
so something I am going to discuss quickly before we get started. There was some breaking news. We learned that there was potentially actually a not guilty verdict on counts 1 and 2 for the Nevada team that we did not hear about. We were told that it was a hung jury. We were told that the only charges that they were decisive about were the 8 counts against Rick Burleson that were guilty, as well as the 2 counts against Todd Burleson that were guilty, and everything else was a hung jury. Where now some things are unraveling. Deb Jordan thankfully shared some things off of Pacer tonight, which is court records, and we're going to hopefully get some more information, because from what we're seeing, it looks like there's more to the story than what we were told by Judge Navarro as far as the verdicts go. Real quick, I'm just going to take this opportunity to take about 3 minutes and talk quickly about something that I think is really important. And I want to talk about Juror 4 and Juror 11 from the Oregon stand-up trial back in October. We talk often about Juror 4 and about how Juror 4 called out Juror 11. Juror 11 was the biased juror who was going to cause it to be a hung jury. And thankfully, the Lord prompted Juror 4 to stand on his integrity and call out Juror 11 as biased. But what a lot of people don't know is what I'm about to say, how Juror 11 actually got removed. When we talk about this, we often say, thank God for Juror 4. Without Juror 4, there would have been a hung jury. And I want to correct that, because it's actually not true. Juror 4 called out Juror 11, and Judge Anna Brown called in Juror 11 and had a very, very short meeting with him and asked him, have you become biased since I met you in voir dire? And he said, no. And he was actually permitted to go back to the jury room. The reason Juror 11 ended up being removed was not simply alone Juror 4 calling him out, but it was the combination of the team that we're looking at right now. Sorry, my phone might die on me. The combination here of Rick Koerber assisting behind the scenes and Morgan Philpot willing to file the motion for mistrial if they did not remove Juror 11. And that didn't come easily. Some of the other attorneys didn't want to move forward with removing Juror 11. We all had speculations on, was Juror 11 for us or against us? If we file this motion and they remove this man and he was the only one who was saying not guilty, we've just brought on a unanimous guilty verdict. But the Lord put it on these men's hearts to stand their ground and to say they don't care what his verdict was. He said he was biased and they wanted him removed from the jury trial. And he was removed. And we know, I think it was either 3 or 5 hours I think it was 3 hours after the new juror was brought on, we had a unanimous not guilty verdict and a great victory in Oregon. So for those of you who've been asking the question, who is Rick Koerber, I want you guys to understand that he was much of the brains behind the scenes in Oregon. And I personally have a ton of gratitude to him for coming on and being willing to just sacrifice his own resources and time to secure that not guilty verdict with the rest of the team. So with that, I'm going to go ahead and turn it over and say, Rick, let's talk about this jury form. Let's talk about the check marks and the not guilty verdict that it looks like has been hidden from the people.
All right, hold on just a second, Kelly. Looks like we might have lost Morgan here. Let's just check real quick. Morgan, doing a quick check. Are you there?
Yeah, I'm here with you.
Oh, there you go. All right, very good. And then let's just make sure we got John as well. John, you there?
I'm here. Yes, I am.
All right, very good. And then let's just check. We've only got, somebody's got a cell phone or something laying next to or on a board or something, and when the messages come in, it's really sending a lot of vibration to everybody. So, see if we can fix that. All right, Kelly, I see 96 people on. Okay. So let's just correct one other thing real quick. I appreciate the description of my involvement. I work as Morgan Philpot's paralegal and law clerk. So when Morgan, I was helping Mike Arnold up in Oregon as a volunteer, and then when there needed to be that change of counsel and Morgan came on, I came onto that case as his paralegal. Obviously, I have a relationship with Marcus Mumford. You mentioned my role down in Nevada. I just, in the interest of candor, I still am working as Morgan's paralegal. So when Morgan got admitted on that case down there, he kind of has to bring me along with him, whether he likes it or not. That's not really true. He could fire me, but so far he hasn't done that. So I just wanted to clarify that. I don't know, Morgan, are you going to bring me along down in Nevada?
Well, of course. I think if I didn't bring you along, Ammon would get pretty mad at me. Are you hearing me very well?
Yeah, I hear you just fine. But again, somebody's phone's vibrating. I don't know if you guys could just hear that. So Kelly, back to you. So in that, we've been a team for a long time, and we've been working on Ammon's team since the day before Lavoy Finicum was killed, actually. So this is kind of a big fight. It's bigger than any one of these individual cases. So now, picking up there, what do you want to talk about first? You want to talk about this news about the jury verdict form? Is that what you wanted to do first?
Well, there's a whole lot of things that I want to talk about. However, tonight I think the main topic is this jury form. We would like to understand some of the behind the scenes that we do know is that last Thursday the jurors were called back or came back into before the judge with a question, and their question was regarding the conspiracy charge. Then that question was sealed, so we really didn't understand what the full question was. And now we're seeing on this jury form that under the conspiracy count 1 and 2, that they reported as a hung jury, that they had actually originally marked not guilty across the board, including Greg Burleson and Todd Engel.
Yeah.
So what can you tell us about that?
Yeah, so there's a lot of things. What's really interesting is, so after, the jury comes into the courtroom and does the actual performance of delivering their verdict, and I don't mean to slight what they do, but court is a live process, and then they reduce their decision formally to orders, etc., and that kind of thing, and there's what's called the court docket, and then the court enters official orders and filings and things like that on the docket. Well, what we noticed and what was brought to our attention by some basically trial observers and candid fans who also are looking at the docket, let's see, on the 24th, it's a docket entry 1903, the court entered the official jury verdict form. And the official jury verdict form is signed by the jury foreperson, and it's the legal document that exists from the time of the verdict onward that legally attests to the result of the trial. And there are other records that get created that don't matter legally, juror notes and things like that, seldom if ever matter. Matter of fact, there's laws that say they can't matter. There's the things that get said in the courtroom that sometimes matter. And one of the things we're actually trying to get a hold of, and we still don't have, is an actual recording of what happened during some of these discussions. Right now, the transcript and those recordings are sealed. That's normal, but we need to get access to those, and I think we have access to those, but we haven't been able to review them since this news started to break. But somebody reviewing the jury verdict form noticed something rather unusual, and that is, on the jury verdict form, they didn't, well, the two things. The first thing, count 1 and count 2, which are the conspiracy charges, which is, you know, this is really the crux of the case. If you read the indictment, the conspiracy against the federal government is the thing that's kept these guys in prison all this time on pretrial detention, and it's the most egregious catch-all offense for lumping all these defendants together, etc. And there are 6 different legal conclusions the jury was asked to make on each of these conspiracy counts, and the jury verdict form reads, as to count 1 of the superseding indictment charging conspiracy to commit an offense against the United States in violation of Title 18 United States Code Section 371, we, the jury, and then it goes through and says, what do we find? Unanimously find, and then it has empty lines for potential check boxes or marks or initials, and under number 1, assault on a federal officer, that's left blank. Under number 2, threatening a federal officer, law enforcement officer, that's left blank. Number 3, use and carry of a firearm in relationship to a crime of violence, that's left blank. Number 4, obstruction of the due administration of justice, that's left blank. Number 5, interference with interstate commerce by extortion, that's left blank. Number 6, interstate travel in aid of extortion, that's left blank. So those were all the different things that the government spent 2 months putting on evidence, trying to prove beyond a reasonable doubt that 1, 2, 3, all of these defendants were guilty of conspiracy against the United States. And then there's a number 7 option, and it says none of the above. If the jury chooses this answer, then the jury must find all defendants not guilty of count 1. And there's a check mark in that area. Now, it's important to know that there are jury instructions that are official court records that are given by the court. They're debated about by the parties, argued about by the parties from before the trial, sometimes through the trial, all the way up until the very end. And the jury instructions tell the jury that what they put on this form has to be their official decision. This isn't like scratch paper. This isn't, like a working draft that you make changes to. If you make mistakes on the jury verdict form, you have to destroy it and get a new jury verdict form because it is the official court document. And what's even more interesting is down on the bottom of that same page, it says, for count 1, we, the jury, unanimously find as to, and then it goes through all 6 of these first defendants, Greg Burleson, Scott Drexler, Todd Engel, Ricky Loveland, Eric Parker, and Stephen Stewart, and the not guilty line is checked on every single one of those, which means at some point in filling out this form, the jury was not hung. The jury had reached a unanimous verdict. They didn't change that. Now, there does appear to be, subsequently, lines, horizontal lines striking over those check marks. There's no indication what that means. Some people have surmised and said, well, that clearly means they were changing their mind. But that's not how this works. You change your mind, you get a new form. Some have suggested that maybe someone went in afterwards, the judge or the clerk went in afterwards and marked those. Highly unlikely. Anything's possible. We don't know. But this is supposed to be the work of the jury. Matter of fact, if you go down to the very end of the document, you'll see this is the official document. It's signed on April 24th by the jury foreperson. Of course, their name's whited out to protect their identity from harassment, but that's knowable. We know who that is. And this is officially docket number 1903. So this is the official jury verdict form. And it shows that the jury, at some point, was unanimously in agreement that all of the defendants were not guilty of count 1. And then it gets even better because it goes to count 2, on page 3 of the jury verdict form, and it does the exact same thing. There's a check mark in none of the above, and there's a check mark in the not guilty area for every single defendant. And then again, there are these horizontal strike marks through those checks. It makes them look like X's, and it also looks like, if you look very carefully, there were some other marks that might be incomplete. We don't know what they are, but here's the other thing that's very interesting. There are no marks in the guilty section. So there's going to have to be some work done here to investigate a little bit further what this represents, but it is obviously a big deal. This is an official verdict form, and it shows, at the very least, that at some point the jury foreperson signed a verdict form where there was unanimous agreement that all of the defendants were found by the jury beyond a reasonable doubt, unanimously, to be not guilty of both of these conspiracy charges. So, again, there's still some questions, obviously. We've got some work going on behind the scenes, but even without all of our questions being answered, there are some serious legal questions and legal issues to be resolved. So, I don't know, is that what you wanted me to point out, Kelly? Is that what you were looking for?
Yeah, you know, another thing is, let's see, is our screens, I don't think our screens are switching, so it's staying.
Are you not, it looks like it switched, you're on.
Oh, there we go, now it switched, yep. Okay. So the other thing to point out is that when the jury came back on Thursday, that they were under the assumption that a not guilty verdict on the conspiracy meant that all other charges were not guilty as well. That was the instruction that the judge gave in the courtroom that other courtroom observers have reported. Actually, last week, was that just last week? I had done a live stream of quoting Andrea Parker, who had also said that if they come back with a not guilty on the conspiracy, that it is not guilty on all other charges. And so what we're seeing here is that the jury heard the same thing that the courtroom observers heard, and that Thursday, is the assumption, before they ended up taking the weekend off, that they were coming back into the courtroom believing that they were giving a not guilty, unanimous not guilty on all charges, since the counts 1 and 2 were being found not guilty.
Yeah.
Which that's an important thing to focus on, that these jurors believed, just like the courtroom observers, what the judge said, which is if count 1 and 2 are not guilty, then all the other charges are also not guilty. If there was no conspiracy to commit a crime against the United States, then all other charges were not guilty as well.
Let's get clear on what probably happened. Now, you and I weren't in the courtroom. Again, Ammon, since I work on Ammon's defense team, we're preparing for this next trial, so I wasn't there. I know we've got good reports from people who are there, but let's talk about where that confusion likely comes from. So, besides counts 1 and 2, of course, there are several other counts on these other charges. For example, aiding interstate commerce, aiding a threat of extortion, and the firearms charges, etc. And what happened is all those charges existed independently. In other words, the jury could have found any one of them guilty of those charges, but separately, those charges can also be predicates for these conspiracies, count 1 and 2. In other words, the jury had to decide. For example, they found Todd Engel apparently guilty on 2 counts, one of which was the interstate commerce, bringing a firearm in interstate commerce as part of extortion. That's a horrible paraphrase, but you guys know what I'm talking about. So then their next question was, did he do that as part of a conspiracy? So there were 2 questions. And it looks like there was some confusion because the jury was ready to find that there was no conspiracy, or in fact they did find at some point unanimously, according to these documents, there's no doubt, there's no ambiguity, they did find at some point unanimously that no one did anything with regard to a conspiracy, and then that question probably created confusion because they were, like you say, going to find Todd Engel guilty of 2 counts and Greg Burleson guilty of several other counts, and they may have thought, oh, that invalidates our not guilty verdict, but it clearly doesn't. And so the question then is, and you know, the question you and I and Morgan and John aren't going to be answer tonight is, well, what do you do about this? Because clearly the jury at some point reached a unanimous conclusion regarding the conspiracy counts. And I think that's what you were trying to allude to, is the concerning part, is, hey, wait a minute, if we had a not guilty verdict at some point, how does that get changed, right?
Right.
So let me share something with our listeners. And John, if you and Morgan want to chime in at any time, I don't want to be doing all the talking, but since I've got some resources here, I thought I'd share those first. But there are a couple important other issues that I think, you know, the people watching this might be interested to know. The other defendants may be interested to know. Their families may be interested to know. So the judge, of course, entered a verdict of guilty on 8 counts for Greg and 2 counts for Todd. And it was declared a mistrial on the other counts. And what a mistrial means, or a hung jury means, it means that the judge found that the jury was undeniably hung, unable basically to come to an answer on these counts. Now we can talk about, there are even some questions about how that happened, but so you know, okay, now there's another hearing date. Now the conversation for the last couple of days is, well, can these guys be retried? And I don't know if you remember on our broadcast yesterday, the question came up about double jeopardy. You know, so do these guys just get retried on the hung counts? Well, if you remember what I told you and what we were all talking about, the answer is yeah. Double jeopardy hasn't attached. You know, and whenever you ask a legal question, whether it's to an attorney or a judge or anybody else, you need to know there's a whole series of asterisks that qualify any answer you ever give. Now that this information has come out about this jury verdict form, which has been formally entered in the case, there is a new double jeopardy question, separate and apart from the fact that it looks like the jury at some point may have reached the verdict of acquittal. I mean, there's going to have to be some investigation of that. Maybe some of these defense attorneys are already aware what happened to that jury verdict form, but there's an issue I haven't heard anybody talking about, and anybody watching, this will be the first place I am aware of anybody's thinking about this. Let me share something with you. In 2007, there was a really prominent case in the Ninth Circuit Court of Appeals where there was a situation where there was a discrepancy between the jury verdict form and the jury's verdict, and they ended up, and I'll save the facts of the case since it's not law school, but they ended up, this defendant ended up getting retried and convicted, and he challenged his conviction on double jeopardy grounds. And I want you to hear what the Ninth Circuit said in 2007, and they're citing a really famous Supreme Court case called Green. And here's what it says. The Supreme Court explained the doctrine of implied acquittal. When a jury convicts on a lesser alternate charge and fails to reach a verdict on the greater charge, without announcing any splits or divisions, and having had a full and fair opportunity to do so, the jury's silence on the second charge is an implied acquittal. A verdict of implied acquittal is final and bars a subsequent prosecution for the same offense. There's another case from the United States Supreme Court that they cited that goes clear back to 1898. This is, again, for some people maybe this is boring, but this is fascinating stuff. And this is a 2007 Ninth Circuit case, so this is the law that governs us in Nevada right now. This is binding legal authority, unless any signs of hopeless deadlock. And then...
Hey, Rick?
Yeah?
Hold up a sec. I think you may have a feed interruption on Facebook.
Okay.
I don't think anybody's hearing you right now.
It still says 364 people.
All right. Maybe I'm off. Sorry, go ahead. I'm not the only one saying it, though. There's a few people posting this.
Well, you know what happens when you start preaching the truth? You know what happens. You start preaching the truth, and the Facebook monitors and censors interfere. All right. So we're good now. Denny says we're back. So where did I cut out? Well, here's the point. There's a legal doctrine that says a jury can acquit you. by a unanimous verdict that says not guilty. Sorry, I'm hesitant now. I want to make sure everybody's still hearing me. Kelly, are you still there? Kelly, I don't hear you. Did you mute yourself?
I did mute myself. My dog was drinking water. I'm sorry.
Oh, yeah, your dog needs to drink water. I just want to make sure that, we're still here. We're back up to 400 viewers, and we were up over 500. So let's...
Okay.
John, are you still with us?
This side is clear, too.
All right.
Yeah, this side says it's clear, too. So.
All right. So what this Ninth Circuit case, it's called Brazel v. Washington. And for those of you who do legal research, you can find that at 491 F. 3rd, 976. And what it says is, separate from an actual acquittal, there are situations where a jury implies acquittal by their silence about deadlock. And here's what I mean. In this case, not only is there a question about whether or not the jury unanimously found at some point a not guilty verdict, there's no marks on the guilty side, and there's no indication in the record that has been filed that the jury was deadlocked on count 1 and 2. Now, we've heard some reports in the media, and we've heard some comments from a couple of the defense lawyers that talked to at least one of the jurors, and they gave us some votes. Remember the 10-2 and the 7-5 votes or whatnot on the conspiracy counts? But what's interesting is that's not reflected on this jury form. So my guess is the reason there was a conversation after the fact with the judge and at least some of the jurors is because there is a question that just because they didn't find a not guilty expressly, there's still this question of a possible implied verdict here. Now, again, it would be premature to then take this and run with it and say that's absolutely the case. I'm just trying to say there's a legitimate legal question as to why we would want to know the answers here. And so what we've got to do is we've got to spend some time over the next day or two. We've got to talk with these criminal defense attorneys who were working on that first trial. We've got to get the recording and the transcript from the judge's conversation with the jury, and we've got to answer these two questions that really are there, at least two big questions. Number one, at some point, is it true that there was a unanimous not guilty verdict and that that's what this jury form reflects? And when did it become ununanimous? Was it before or after the Allen charge? Because that would be a big deal. And then the second thing is, if the jury verdict form is entered this way, does it give us legal grounds to argue that double jeopardy should preclude Greg and Scott and Todd and Ricky and Eric and Stephen from being retried on the conspiracy counts? Now, of course, if you view things from the government's perspective and a prosecutor's perspective, your answer is going to be immediately no. You guys quit being crazy. Quit raising these issues. But any fair person who sees a jury verdict form like this would have questions. And any defense attorney worth an ounce of being a defense attorney must know the answers to those questions. So for when you and I were talking earlier, and I got some messages from other people, the point of my whole presentation here tonight is it is absolutely legitimate to have questions. It's absolutely normal and sane. You don't have to be a conspiracy theorist. You don't have to be, up in the night. There are some serious questions raised by just what is referenced on that jury verdict form. So,
can I ask a question? You said that if this changed after the Allen charge, what would the significance of that be? Can you let us know why that would matter?
Well, because generally what the reports are that we had is that the jury came back after the weekend and said that they had a certain agreement and certain disagreement. And at that point, there was a discussion in the courtroom. And if you read, I'm reading from the official summary by the court reporter. Here's what it says. This is jury trial day 32 minutes. And this is basically Judge Navarro's official accounting of what happened. But again, there's still going to be a recording and there's still going to be a transcript. But this is what has been entered as docket 1887. And here's what it says. The court, having received a note from the jury, convenes outside the presence of the jury. The court admonishes the parties regarding courtroom demeanor. The court and the parties discuss the jury note. The court hears argument regarding providing an Allen charge to the jury on deadlocked counts. See, it doesn't say there what counts were deadlocked. The defendants do not request providing an Allen charge. The government requests the court provide the jury with an Allen charge. So the government wanted an Allen charge, and the defense didn't request an Allen charge. And then it says the court will accept the unanimous verdict and provide an Allen charge on the remaining deadlocked verdicts. So the point is, if this verdict form was filled out and signed on these counts before that Allen charge was made, then the court, by order, accepted that verdict. And when they went back into the jury room, if that's what happened and they crossed it out, there would be a question here, a very legitimate legal question about whether that was permissible at all legally. The other issue is people might not know what an Allen charge is, and we don't have time to go into all that, but an Allen charge generally is where the judge says, look, you can't give up. You need to go back and try harder. And another reason why it would be important is to whether this change happened before or after that Allen charge is the Allen charge isn't allowed to be used to undo verdicts. It's not legally tenable to have basically a judge say, you're wrong, go undo that. And so that's another reason why a good defense attorney would want to look at this and say, let's make sure we have answers to these questions. And now, some of these other defense attorneys, they just went through a 2-month trial. Somebody was complaining to me, how come we haven't heard from them? We've been waiting several hours to get feedback from them. And I'm like, well, they just sat through 2 months of trial. They probably spending some time with family. So let's not, the legal issues here aren't going to get resolved in a day or two anyway, even if everything were to be found completely in the defendant's favor here. You're still, these guys are still going to be in jail. They're still going to be awaiting possible retrial. It does make things a lot different and change the landscape. But let's not get mad at these attorneys for not. They may have some answers that would help us on this. But that's why, in answer to your question, Kelly, it would be very important to know whether those horizontal marks crossing out the check marks of a unanimous not guilty happened before or after the judge said, okay, we're accepting the unanimous verdict. It would be very important to know.
Okay, so then towards my last question will be, if these other defense attorneys are saying, this really isn't that big of a deal, they changed their mind, we're going to move forward with what the judge said to us, is there anything that you guys or those of us on the outside can do to try to get this information and do something with it? Or are we just kind of at the mercy of the defense attorneys?
Time. It's going to take a couple days. Nobody needs to do anything right now. The people who brought this to our attention is very good, great, thank you, and keep on it in terms of making sure people are wanting to know the answers. But there are answers to these questions. It's not a mystery. Nobody's hiding this. The recording is available. The transcripts are available. We will know in a day or two or three. My guess is by the weekend we'll know the answers to these questions. And then the question is, now what do we do? What do we do as a defense team? What do the other defense teams do? What do the supporters do? And those kind of things. So. Okay. All right. It sounded like somebody wanted to chime in. Was that you, Morgan? Were you wanting to chime in?
No, that wasn't me.
Oh, okay. John?
I'll chime in a minute here, if it's okay, and give a little update from the ground what we were actually seeing there. Am I coming in clearly?
Yeah.
Okay, so here on the ground, the first juror's question that we came across there, it was that one was sealed, and that's what we thought, at least being there on the ground, that's what we thought that the jurors were. I'll turn down the volume here. I'm hearing, but that's where we thought that the jurors actually had come up with a verdict the first time. and that they had a question, and the judge sealed that, so we didn't know what was happening. They was confused about what the judge had said in court. It sounded like to us that the judge was saying that if they found them guilty on the conspiracy, then they would continue. But if they found them not guilty on the conspiracy, that they was not guilty on everything else. And that's kind of what got conveyed to us in court as court watchers. But that was sealed, so we actually didn't know the exact question there. But that's what we understood.
Yeah, and I think that's where this confusion came along, which is if you find them not guilty of the predicates, you have to find them not guilty of the conspiracy, period. But if you find them guilty of the predicate, the question is also, are they also guilty of the conspiracy on top of that? So if you find them guilty of extortion, aiding extortion, now the question is, were they aiding extortion in addition to the conspiracy? And yeah, I think you're right. There may have been some confusion there. We can't really do anything about that. These defense attorneys, very well, for the ones who got guilty verdicts after sentencing, they could appeal based on the argument of jury confusion. But at this point, what will happen is these guys are in jeopardy still, and the prosecution still has the opportunity, the United States has the opportunity to put them on trial again. And if they decide to do that, it's going to be an interesting question about, how do we avoid any confusion going forward, because we all hopefully are learning from that potential confusion here. So, does that make sense? Did I talk past you, or did I answer what you're talking about?
No, I totally understood you there. That cleared it up well.
Okay. Very good. All right, Kelly. I've been talking too much.
It's kind of nice not having to talk. I think where John was going with it too was just kind of bringing out that focused attention that these jurors were prepared to acquit. That they were prepared, even if they. So Greg Burleson, who's facing 57 years, 55 years as a minimum, this jury was prepared to acquit him. If they thought he was truly that dangerous, they had the opportunity to search harder for a conspiracy with Greg. I mean, we know the courts make things up. Look at the conspiracy charge that came down between Daryl Thorne and Jason Patrick in Oregon. We know there was no conspiracy there, and the jury still found them guilty of conspiracy to impede. So if this jury was that concerned about these people as far as a threat risk goes, it's hard for me to believe that they would have come back with unanimous not guilty on counts 1 and 2, knowing that was going to set these men free. That shows me the heart of these jurors, that they believe the innocence of these people. And it also shows me personally that even though they found Greg guilty, once they were given permission to go back and look at other charges after they realized they didn't have to have the conspiracy deciding the other charges, that even though they found him guilty, that they were fine to acquit him and find him not guilty of the conspiracy, knowing he would walk. Now, if they were willing to let him walk on and find him not guilty on the conspiracy charge, why then did they come back with a hung jury on the conspiracy after it shows so much confusion to these poor jurors, because if they were unanimous on the conspiracy, now they're given permission to go back and find people guilty of other charges. They find Greg Burleson guilty of everything except the conspiracy, but they didn't find him not guilty. They reported a hung jury. So it shows that there was obviously confusion in this jury room. There was confusion outside of the jury room to the supporters as well. I think Judge Navarro has been confused most of this case, just based on her own bantering back and forth and trying to understand things between her and the prosecution. That's just my opinion. But clearly there was misinformation given, because the supporters and the jurors believed that if conspiracy was not guilty, that all other charges were released. And I think that goes to show that these men are not even viewed by these jurors who found Greg Burleson guilty. They're not viewed as a threat to society, and yet they're still sitting incarcerated, denied bail 14 months, 2 of which are sitting in solitary confinement today. And we had jurors that were ready to let them all walk.
Well, and obviously we want to look for all the encouraging signs that we can find, but let me just temper some of what I think I heard you say. Whether if we are confused, if people outside the courtroom are confused, that's by design. I mean, that's why there's rules that exclude people from the courtroom. That's why there's rules of evidence, and it's always. And listen, I've been doing this long enough. It always feels unfair when anything gets excluded that you want in, and these kind of things. And I'm not defending this court process. I'm not saying it was completely fair. I'm saying we need to be careful that we don't exist in an echo chamber and make poor strategic decisions, because some of the jurors were interviewed by the media and by the attorneys afterwards, and some of those jurors made they made no bones about it. They thought that Greg was guilty of all the counts they convicted him of, and they were not happy with Todd at all. One of the jurors, it was really brutal about Todd and what that juror thought about Todd's performance. They were also very critical of the government. They didn't believe the government witnesses, with all these FBI agents coming up and saying they were scared for their lives and all these kind of things. So I agree with you that if there was juror confusion about how their jury instructions were to be followed and how this jury verdict was supposed to be delivered, that is definitely grounds for an appeal. But I wouldn't read the jury's actions here as saying that they were willing to find Greg or Todd not guilty on these other subsequent counts. I don't remember. There was unanimous guilty on those. And so now maybe if it were more fair, maybe if some other evidence had been introduced, maybe if they hadn't been confused, you're right. I think, that's one of the principles of our court system is we don't get to go back and decide whether a jury verdict is legitimate or illegitimate by hashing 1,000 what ifs. There are kind of certain legal standards and due process, and under both the Sixth Amendment and the Fifth Amendment, your right to a fair trial. There is an argument here if there was jury confusion on these counts, but I don't know anything that would cause juror confusion on the counts that were convicted. I haven't seen anything or heard anything. Matter of fact, I think the jurors that were interviewed after were pretty clear there wasn't any confusion about those. So.
Yeah.
I mean, I wish
even at that, if you go back to the whole idea of due process and the conversation we had the other night about Longbow. Yeah. If the Longbow production hadn't been at play, if he hadn't been intoxicated and been asked the questions he did, there's a very, 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 very good chance that Greg Burleson would not have been convicted.
Listen, these guys they've got lots of issues that I see for potential appeal. So again, don't interpret my remarks as defending how things played out. I'm just, as I work on the defense all the time. Not just in this case. With Morgan and other attorneys on lots of cases. In my own case, I've been fighting my own case for 8 years, as you know. And one of the downsides is when you're so passionate about your side, you tend to only listen to the arguments that help you understand your position, and you don't try real hard to see maybe what you're up against, because the judges, unfortunately, they're in the exact opposite position. And if you want to try to persuade these judges, we've got to say, okay, here's what happened, and this is where I think we go forward from here. What do we learn from this that we can hammer and attack and defend and vigorously put forward the best defense we can? What weak spots do we see now? And clearly the fact that the jury at some point had marked not guilty on the conspiracy counts, clearly that is a sign of a Achilles heel, if you will. And of course, we've all known this, how absurd this is, that these men are being called enemies of the United States and conspirators against the United States. But there's evidence to say, yeah, and so did the jurors. The jurors said, yeah, maybe Greg did these things that were wrong, maybe Todd did these things that were wrong, but the jurors, there's no evidence that after 2 months, the jurors believed that there was a conspiracy. In fact, the evidence is the opposite. The evidence is that all 12 of them at some point believed there wasn't a conspiracy. And so that's the best takeaway of this whole thing. Now, to make it even better, let me share with you another quote real quick on the law, on these implied acquittals. Because even if let me just tell you, and again, I don't want anybody to get too terribly excited here because I'm not working on the defense team for any of these 6 defendants, and so I'm just talking to you as a citizen, saying, hey, if you were my sister and you were on trial and this had happened to you, here's what would be giving me hope and encouragement. That's all I'm saying. I'm not giving legal advice or anything like that. But going back to that Ninth Circuit case, listen to what it says. It says, in contrast to an implied acquittal, retrial is permitted where there is a mistrial declared due to, quote, manifest necessity presented by a hung jury. A hung jury occurs when there is an irreconcilable disagreement among the jury members. A high degree of necessity is required to establish a mistrial due to the hopeless deadlock of jury members. Now, let me explain to you what I'm doing here. Sorry, let me come back on this. It says, a high degree of necessity is required to establish a mistrial. The record should reflect that the jury is, quote, genuinely deadlocked. And then it cites the law. Well, let me just tell you, another thing about this is this jury verdict form calls into question whether this jury was genuinely deadlocked on counts 1 and 2. I would argue it shows beyond you by preponderance of the evidence that they were not genuinely deadlocked on those counts. And because of that, I think a defense potentially has the argument, all right, we didn't get an acquittal, but there's an implied acquittal, which means they cannot retry us on those 2 conspiracy counts. And I'm telling you, if you won that argument, I think it's a whole new world for these 6 defendants because that's the kind of mistake that courts make and that juries make that attorneys sometimes don't notice because they check out. They're like, okay, we're done. And I'm not saying anything about these attorneys. I'm just saying generally, these are the kind of things, I work a lot on appellate issues over the last 7 years, and a lot of times that's what you're looking for. Hey, were there mistakes made in the law? And the Supreme Court has made this very clear. The Supreme Court has said that after the case has been submitted to the jury and they report their inability to agree and the court made a record of it and discharges them, such discharge would not be the equivalent to an acquittal since it would not bar the further prosecution. But then the Supreme Court goes on to say, but this is only true if the jury is truly hung based on irreconcilable disagreement among the jury members. Now, I don't know how you argue that there was irreconcilable disagreement. When was there irreconcilable? After there was reconcilable disagreement among the members? And so, again, if the Allen charge blew this up and caused them to go back and believe, like you say, oh, we can't find them not guilty on these counts because that means we couldn't find them guilty on these other counts, so let's scratch that. I think these guys have at least an argument that there's an implied acquittal and the Fifth Amendment double jeopardy protection cuts in. And again, conceptually, there are still some answers to these questions.
I've got a question about Todd Engel, if good.
Wait, the screen is stuck on me. Can you change it to John?
It's not stuck on you, it's just delayed a little bit. The audio and the video just aren't completely synced.
You might have to put yours on mute and it'll go off. But, so what I got a question about Todd Engel. That is one of the guidelines because his charges could not be grouped together. And we're wanting to know if they're going to
hold up there, John. Hey, Rick, you need to mute yours. Yours is causing him to have some serious feedback as well as mine. There you go.
Oh, that's a lot quieter now. So I guess the question is about Todd Engel's charges, whether they were going to be the guidelines, sentencing guidelines say that count 12 and 16 aren't able to be grouped. So does that impact whether or not the sentencing can be served concurrently?
Well, the sentencing is a whole different ball game. There's actually lots of issues that are going to weigh into sentencing on these, and whether the mistrial goes forward and a new trial comes in, that's also going to weigh in. So I haven't examined that. The answer to your question is there's too many asterisks there's too many conditions there's too many variables in that mathematical equation to answer that question today. Did you guys hear that? Are we good?
Yeah, I heard you there real good. So, okay, that answered my question for Todd. Thanks a lot.
All right.
Yeah.
You know, for our listeners, I hope you all appreciate that this technology where we're combining Google Hangouts with Facebook Live. We're still a little new. This is the second time we've done this, but I've never seen it done on Facebook Live before, where you can have 4 people participating on video. So I'm kind of proud of the fact that we're doing that. I'd love your guys' feedback on whether you find it useful or whether the people watching like that style. So.
Okay, so I think that we've probably answered everything that we can answer at this point as far as the jury verdict form, but I think we have a reason to be excited that there's something to look into, that, it isn't just all what we were told in the jury room or in the courtroom as far as the verdicts go. And we're going to be praying that it's something that works in the benefit. So for our viewers out there, please be praying for these guys, that this creates just enough of a conflict for the government that perhaps they'll just dismiss the charges. And then at that point, at least the ones that had the hung jury on, and maybe decide not to retry them. I think that'd obviously be the best case scenario. Awesome. So is there anything you wanted to add, Morgan?
No, somebody had asked why I'm not piping in as much. Part of that is there are ethical rules on extrajudicial statements by attorneys, and we have to be very careful about what we say outside of court. And in fact, they govern the risk of dissemination of information to the public in a way that could materially prejudice a trial or the outcome of a trial. And so we all serve our purpose here, and Rick and Kelly and John do an excellent job of taking care of public dissemination of information, and I try to just sit back and help and make sure I stay abreast of all the issues and keep in touch with everyone as best I can.
All right, so before we end this, I just want to take a quick minute, if I can, to talk about Ammon and Ryan's solitary confinement. Are you guys okay with that?
Yeah.
So the other night, I was able to talk to Ammon, and he wanted me to get something out as far as the treatment in the jail goes. And he wants people to understand that the abuse that all of these defendants are facing, that it's not just our justice system. It's not just the policies at the prison that they're having to endure what they're having to endure. He told me that next to him in his cell, there is a man that is convicted of either murder or attempted murder. And that every single day when his food is delivered, that he takes his feces and he rolls it up in toilet paper and he throws it at the guards. And he said this has been going on for weeks, and the man still has all of his phone privileges and he still has all of his commissary. And Ammon and Ryan in solitary have very, very limited phone privileges, and they have no commissary. So that means no extra stamps, letters, pens, papers, any of that. Food, extra food, they're fed just junk in these jails. And so he wanted the American people to understand that when he is talking about the abuse that they're enduring, he's not just trying to complain, woe is me, everybody's suffering through this, but I can't handle it. He's trying to let people understand that they truly are political prisoners, that the rules are not being applied to them as individuals because of the political stand that these individuals have taken. And then as far as the approach that Ammon and Ryan have taken right now, refusing the strip searches, something that he had said is, if every one of the defendants or if all of the guys in there that have not been convicted of a crime refused to have unwarranted searches of their bodies done. If they chose to protest that and stand on their constitutionally protected rights, they should have already been granted bail. They're not being granted bail. And if they said, you know what, I've been convicted of no crime, I've done nothing wrong, I will be acquitted of my charges. I'm not going to subject myself to searches that criminals have to endure because of their misconduct, because I have not done those things. If every one of the defendants chose to do that, perhaps by the time trial came, this would be making some bigger headlines as to how many people have been sitting in solitary confinement. And he's not trying to say other people need to do what is a conviction of his. He's just simply making the point that when only a few people choose to stand up, the suffering is usually much worse, and it has to go on for much longer periods of time before change happens, because the public is not awakened the same as when large groups of people do things. Principled things like this, saying, I'm not guilty of a crime, I'm not going to subject myself to these searches. If, for anybody who's been really confused or questioning them, even maybe other defendants that are saying, just kind of get with the program, his response was, I'm not going to keep begging for the scraps of the king. You'll let me see my attorney, you'll let me make phone calls, you'll let me have commissary if I just let you search my body. Okay, I'll give up this constitutionally protected right against this unwarranted search of my persons so that I can have a little bit more of your scraps. Ammon and Ryan are saying, I don't want your scraps. I want my constitutionally protected rights. This is America. And so I guess I'm just asking the people, the supporters, to come behind them on this. And even if you don't understand their form of protest that they're doing right now, if you could pray for them, and if you could do your best to stand behind them, knowing that they're not trying to make trouble, they're truly doing what is a conviction to them, what God has put on their heart. They believe that that in time change will come because of the actions that they're taking right now, not just change for them, but many, many other people across the board that are having to endure this treatment when they've been denied bail. So they're greatly suffering. They are they're mistreated beyond what we could imagine. And to put yourself in their place and to think, I've been convicted of a crime, but don't worry, I'll prove my innocence when court comes. And then to already be subjected to this level of suffering before you even get to prove your innocence, it implies that you are guilty of that crime, or he wouldn't be sitting in jail right now. The government has already said to him, you are guilty of this crime. And so that is what he is protesting, and I commend him for that, and I commend Ryan for that, and I just hope that the supporters can see what they're doing and come behind him on that and really pray for them right now, because they truly are suffering right now.
Hey, Kelli, can I pipe in a little bit on that? This is actually a both horrible and fascinating aspect of this case, and I can talk in a kind of a backward-looking manner on this issue as we look back on Oregon, right? I'm not gonna talk a whole lot about what's going on now. Kelly's covered that really well, but if you look back at Oregon and the detention of these men in Oregon, they were categorized largely as domestic terrorists. And if you were in Oregon, you probably noticed that there was Homeland Security constantly ever present. The FBI teams that were brought in to testify in Oregon came out of areas like Seattle, Washington, because that's where their domestic terrorism investigative unit was. And this is a relatively new area of law where these men are referred to in jail as detainees, a little bit like you'd think of a terrorist who is being detained. And there's some interesting literature out there and even commentary, most of it coming from the left side of the political spectrum, coincidentally, or perhaps ironically, relative to the way, let's say, an eco-terrorist is treated in jail. And what I like to tell people is, you imagine that there is a line that divides the normal, Americans from the fringe Americans. which is an offensive concept for many of us, right? And if the FBI can successfully investigate and the United States government can successfully prosecute somebody who looks like they're just over that line, what does that say about what they can then do to somebody tomorrow who's just over that line? It's a really frightening prospect, and the way that they get to treat these people who are categorized as domestic terrorists or detainees is a frightening civil rights and constitutional concept for every single American, no matter what part of the political spectrum you fall onto. And it's something that we all need to be very aware of and help make our neighbors aware of as well, because these men are protesting that treatment, which is, in my opinion, very inhumane.
Mm-hmm. Thank you for that. Yeah, I would agree. There's been studies done on solitary confinement and on your eyesight and how solitary confinement damages your long-term vision. And it doesn't take very long to do that. And I don't remember all the data on it, but for the nerves in your eye to start dying from not being used, from the long-term, long-distance vision not being used. So if you can imagine now 30 plus days of sitting in I think it's 4 foot by 7 foot, Ryan can stretch his arms out and touch both sides of his cell, and then looking all the way up and seeing a solid wall for 30 days and having your government continuously telling you, oh no, you're innocent. You maintain your innocence still. You haven't been proven guilty of a crime. It's ludicrous that they're able to tell us that we get this right of being innocent until proven guilty, and then treat us as though we're guilty. And we should see it as us, that this is how they are treating us as the American people, because what they can do to one American, they can do to all Americans. So I do hope people will engage with that and show Ammon and Ryan the support for what they're doing, because it's really quite remarkable. Yeah. If you think back to the end scene of Braveheart, when the woman, and I can never remember her name, but she's trying to get Mel Gibson to take the potion, and she wants him to take it because it makes her life feel better, because she knows he's not suffering so greatly. And she says, take this, it will dull your suffering. And he says, but it will dull my wits. That's what Ammon and Ryan are saying right now. If we take this gift of getting out of solitary confinement, it will dull our wits. And we're standing up for something that is so much greater than our current suffering. And so we're willing to do this all the way and not do it halfway and accept little bits of, of gifts from the king to try to make the suffering a little bit easier. And so I don't know, maybe we can just close on that, just remembering these guys. All of them are suffering greatly, but some even more so than others. So pray for them, pray for their families, because they know what they're living in every day. And I don't know about you guys, but if that was your husband or your son or your brother that you knew right now is sitting in a cage, in a box, and can't even see out to see other human beings when he's fed because they feed him through a hole in the door, how would that affect your coming and your going? How would that affect how you go shopping and if you go visit friends or not? So the suffering that the families are going through is also great. So to just to keep them in your prayers also.
Hey, Kelli, I wanted to also chime in before we got off here, not to take any distraction from what you're saying. I think there's great value in everything you were just saying. I was reading some of the comments as you were talking, and I wanted to answer a couple other questions. You know, you're talking about how bad they're being treated, and someone said, well, what are Ammon and Ryan's attorneys doing about this? And I'm not an attorney. I have spent years learning how to support these guys, and whatever value I can create for the attorneys to fight, that's for them to approve of or not. But let me explain what I've learned by watching attorneys like Morgan Philpot and attorneys like Marcus Mumford. You know, they've got wives and children and families too, and you guys, the supporters, probably have no idea if you know attorneys from like Hollywood movies, or you've had bad attorneys. These guys, let's take for example in Oregon. We all lived in Oregon for 2 months away from our families, away from our children, in small little rooms. We would wake up, we would shower, get our clothes on, we would go to the courthouse, go through all the security, we would spend all day in court, and then we would go grab a bite to eat, and we would literally go back and we would be interviewing witnesses, or we would be writing. I don't remember a single night in 2 months that we went to bed before midnight. Morgan, he was always an early go-to-sleep guy. I think by 2:30 or 3 a.m. he was usually trying to get some sleep. Mumford and I were drinking 5-hour energy drinks, and sometimes there were several nights when we didn't even sleep, and we just went back the next day, and we did that for 2 months. And there was still more we could have done. We were putting on the best fight we could possibly put on. And you want to know how did Marcus Mumford end up getting tased in the Oregon trial? By that point, he had given everything. Morgan had given everything. I had given everything, because we know that Ammon and Ryan and Ryan and Mel and Davey, all these other people up in Oregon, the other defendants up there, they were giving everything. And you get so passionate, you get into this. I get a little frustrated when I hear somebody say, well, what are the attorneys doing? Even now, in the pretrial lead-up to Oregon, for us and our team, we already... You just don't know. You don't know. I know, Morgan, you probably don't. I won't go into the details, but, Morgan is working entirely off donations. He came to help in Ammon's defense. He paid the bill to go down to see Ammon to first find out if Ammon wanted additional representation. We all pay the bills for our own expenses, for like our phone contacts and all the other things we're doing. And Morgan paid his own expenses to go down to the court to even have, they had to have a hearing on whether he could even be admitted to represent Ammon, and he footed his own bill for that. I just want people to know, are there 5 other, would we like 5 other attorneys and 10 other paralegals and 10 other investigators to kind of match the resources that the federal government throws at this? Yeah, but here's kind of the point. You're never going to hear Morgan Philpot whine about that. You're never going to hear Marcus Mumford whine about that. You're never going to hear attorneys whine about that, because there are 2 different kinds of attorneys. One attorney makes excuses, and the other attorneys fight until they win. There's an old saying I heard once that said, it was, and I don't know if it was true, it's lore about a tribe in Africa that for some reason their rain dance always produced rain. And they elevated in their social status because all the other tribes around them figured that they were more religious, more righteous, more pious, because their rain dance always produced rain. And the story goes that someone finally asked the leader of this tribe, what is it that gives you such a special connection with the heavens, or such a special connection that your rain dance always produce rain, where these other tribes, their rain dances don't produce rain? And the leader of this tribe, again, I don't know that it's true, but the lore is, he said, well, there's one difference between our tribe and everybody else's. When we start a rain dance, we dance until it rains. Now think about that. There's 2 kinds of defense attorneys. There are some defense attorneys who defend until they can't, do it anymore, and then they move on. And there's some defense attorneys who defend until it rains. And I saw those comments, and I just thought, you have no idea what the Morgan Philpot, and there aren't many of them, and the Marcus Mumfords of the world are putting in to these defenses. And so if you do have the ability to support them and help them, it is well worth it. And I know Morgan's going to kick my butt after this call for going into that, but you just need to know, just like you, there are people in this, on the defense side, in the law firms, that this is more than a job. This is a cause. And that this case is more than about the Bundys or Bundy Ranch. This case is about liberty and the cause of liberty. And it would do people well to realize who we're fighting. I will say one last thing. Some people want to criticize the different people involved. Criticize me, criticize Kelly. I saw people criticizing John absurdly on our last call. Criticize Morgan. Do you not understand that the source of your criticism is often from the same people that we're fighting, who are doing these horrible things to Ammon and Ryan in the prison? I used to say on my radio show all the time, wake up, turn your brain on. We need your brain if we're going to be in this together. My brothers, my compatriots in arms, we got to be awake. There's an old movie called Swingers. We got to put our glasses on so we can see who our friends really are, and we got to not be pointing our muskets at each other. And so anyway, Kelly, I had to give a speech. It's late at night again, so I had to go back and add my little 2-cent monologue there. So you're muted. You're still muted. You're muted. You got to unmute yourself.
Remember this whole thing? Okay. So I did buy a small microphone. I even ordered a little tripod, something rather.
Turn your phone sideways. Turn your phone sideways. Watch what happens.
Like that?
Bam! Look at that. Everybody give that a thumbs up if you think that's like 2,000 times better.
What was it before?
Well, see, what happens is when you do portrait, it just gives you a small little sliver in the middle of the screen, and when you turn it sideways, it fills up the whole screen. Now let's see if John let's see if John can do it too. Watch this. Let's go check John out. Look at that. Bam! Look at that! Look at that! Bam! All right.
Hey, we're all new to this. We're trying to figure this out.
Is that better there now?
Oh yeah. Now let's check Morgan out. Hold on. Let's check Morgan. Morgan, come on. We're gonna summon you. Come on back.
Morgan's hiding.
There, look at, he turned his phone. So, you guys, let's see. Last broadcast we had technical problems. Now we've increased our technical proficiency. Tune in for the third broadcast, and we'll even
amazing.
Maybe we'll even be able to put the documents on the screen that we're looking at, and somebody,
I know, right?
Somebody was saying
we need David Fry. Although Gavin's been giving all these pointers to me too, and so I just laugh every time he sends messages and tells me to do things. But we're learning, guys. This is not a full-time job for us. This is not where we anticipated being. But what I was starting to say is I did order a little microphone. People have been complaining about sound. I ordered a tripod thing to hold my phone. So we'll get better at this, guys, by the next trial. We are going to be doing another video soon in the next couple days, and we're going to talk about money. And it's a very awkward thing. Most people don't like to talk about it. I don't like to deal with it. But people want to understand why we're raising money, who it's going to, where money in the past has gone, who's paid for what in the legal defense teams. And this is something Lisa and I were talking through, and she was kind of telling me what she felt comfortable sharing, because there's a ton of misinformation out there about kind of who has done what and where funds have come from. And so some of it will just be helpful to kind of have a talk about it and help people to understand who's really given their all into this, so that we can take away the distractions of, pointing fingers or wondering, well, why aren't they contributing more or less or whatnot. So we'll cover all that and be able to address more of, talking kind of upfront of, see, now my head is cut off. See, I'm not good at this. I'm talking more upfront about what these teams have already donated of their resources and their time, because we think what that will help is, this little thing won't sit straight. We think it will help the community as a whole to come on board and to see what a team we have here, and to also think of it as when one person has the resources and shares it with the others, it's not the time to point fingers at that person and say, why did they have so much money, or where did they get their money? It's the time to rejoice that those people are in our midst. And so, I think that's all. We'll talk more about that in the next couple days, and hopefully it'll help clear up some questions people have and get more people kind of on board to see what this cause is that we're asking you guys to come on board with and help. So,
all right,
that's it. Does anybody else have any major questions? I haven't been reading.
It's awesome. Thanks, Kelly. Thanks for all you're doing. You're awesome.
Yeah, absolutely.
John, thanks for everything.
Thanks, everyone.
All right, guys, thanks for tuning in, and we'll keep you guys posted about these jury forms, and hopefully do another video once we have some answers from the courts.
Awesome. So
with that, we're going to tune out and say, everybody go take your stand, whatever that looks like for you. Be principled, be godly, but it's time to stand up. So that's all. Have a good night, guys.